Good morning, all. And the topic of this morning's video is the double empathy problem applied to courtroom demeanor evaluation. Damian Milton's core claim is that communication breakdown between autistic and non-autistic people is bidirectional and relational, not a one-way deficit located within the autistic person. Both groups are equally poor at reading each other across the neurotype gap. Autistic people read other autistic people accurately, and non-autistic people read other non-autistic people accurately. The impairment narrative comes from measuring autistic communication against non-autistic norms and calling the mismatch a disorder, lack of credibility, or vexatious litigation. Courts run entirely on non-autistic norms of credibility assessment, and those norms are almost never made explicit. They're absorbed as common sense about how honest, trustworthy people act. That's exactly where the double empathy problem does its damage. And so now, before I continue, I want to tell you all what happened to me and my husband. I am a diagnosed autistic person, and we are together, my husband and I, an autism family. And so I published several videos already about how we were walked off our horse farm 17 weeks ago. Well, more than 17 weeks ago. It was 17 weeks ago that they intentionally murdered my 30-year-old autism horse, Gulliver. But we were walked off the farm we were purchasing with a mortgage loan dispersed that we signed for on April 15th, 2026. And we have not gotten a court hearing whatsoever. Now, that situation involves one of the two judges I'm going to talk about today, the Honorable Circuit Judge George Micah Wright, George M. Wright. But I'm also going to talk about what happened with the other local county judge, D. Tatum Davis, and what happened on our writ of certiorari and writ for prohibition or mandamus taken to the Honorable George M. Wright over the Honorable Judge D. Tatum Davis's decision. So when we were walked off our horse farm that we were purchasing and authorized to be on by the fact of those purchase documents and having been there 7.5 years and paid for and labored on and put over $415,000 of our money and property and labor into horse barn, shed, fencing, and dirt work improvements to the property, it dumped all our property, our Horse Business LLC's property, and 2 special needs trust property into my husband's second barber shop. And I've done a video on that. That barber shop was owned by Scott's Laundry Inc., DBA, Allen's Attic. At that barber shop, the individual whose corporation it was who owned the barbershop premises cut off the electric power. And that was done on around June 23rd, 2026. And the barbershop had to be operated with a generator after that because he said, unless you pay me 3 months rent, I'm not turning the power back on. It was an untenable shop. It flooded. And my husband had to dig a ditch, so there was a repair and deduct, and there was a dispute about who owed who what. So the individual whose corporation it was, to evade having to hire a lawyer because he was a corporation, sued for an eviction. And we asked for a rent registry hearing because when the power is cut off by self-help and it devastates customers wanting to come in and pay for haircuts, and the shop floods and it's untenable, then there is a dispute over how much, if any, rent should be deposited in the rent registry. And so we were given a Zoom hearing by 8th Judicial Circuit of Florida County Judge, Honorable D. Tatum Davis. And at that hearing, which was a little over a week ago, we submitted documentary evidence that we were going to ask to have admitted into evidence on the morning of the hearing. And the reason for that is that that's when it was submitted is I require extra time. I got it on my bar exam. I'm autistic. I have bottom-up language processing, and that takes extra time. Instead, we got dressed down by the judge over that. So there's autism discrimination right off the bat, but it got worse. We laid out all the costs on our side that should be deducted from any rent being requested. The other side claimed it was owed a little over $2,900. And when we asked the judge to have him tell us exactly what it was for, he said, well, I'm not even really sure. I'm not sure what it's for. And then he said the rent was $500 a month and there were 3 months. So, okay, so there's $1,500. So he almost doubled it. So what was the rest of it for? We don't know. But the judge weighed the credibility. And then this is a Florida State Court judge. And then he pronounced that I find the individual suing to evict and obtain rent paid in the rent registry more credible than you. Okay, so now this is an actual live example of what happened to us on the basis of my being autistic. So I'm going to continue now with the double empathy problem. And this is the background of the Honorable County Judge D. Tatum Davis. And he's got quite a cultivated career trajectory here. The one thing you don't see in this is any specific autism educational training. Courts run entirely on non-autistic norms of credibility assessment, and those norms are almost never made explicit. They're absorbed as common sense about how honest, trustworthy people act. That's exactly where the double empathy problem does its damage. Specific demeanor cues judges are trained formally and informally to read, and how they misfire on autistic witnesses and litigants. Eye contact. Sustained eye contact reads as confidence and honesty to neurotypical observers. Avoidance reads as deception or evasiveness. For many autistic people, eye contact is effortful or aversive, and reduced eye contact has zero correlation with truthfulness. The judge isn't measuring honesty. They're measuring conformity to a neurotypical display rule. like as in the way a male peacock displays his tail feathers. Affect and prosody, flat or atypical vocal tone, reduced facial expressiveness, or inappropriate effect, e.g. not appearing sufficiently distressed while describing distressing events, gets coded as callousness, indifference, or fabrication. Autistic affect often does not track internal state the way neurotypical affect does. This is a well-documented mismatch, not evidence of anything about the underlying testimony. Literalism and precision. Autistic witnesses often answer exactly the question asked, including pointing out ambiguity, refusing to guess, or giving qualified answers, e.g., it depends on what you mean by X. Attorneys and judges trained on neurotypical conversational norms can read this as evasive, argumentative, or hostile when it's frequently the most accurate form of testimony available. Literal precision is a feature or trait of autistic language, not a dodge. Repetition, info dumping, or tangents. Under stress, some autistic people default to detailed sequential explanation, an emotional regulation and processing strategy that reads to neurotypical listeners as rambling, non-responsive, or trying to obscure something. Response latency, longer processing time before answering or needing a question repeated or rephrased, can read as evasiveness or thinking up a story rather than what it actually is. Different auditory processing speed or difficulty with rapid-fire courtroom question format. Emotional regulation under cross-examination. Meltdown, shutdown, or apparent overreaction to procedural stress can be read as instability or unreliability when it's a predictable neurological response to sensory or social overload in an adversarial high-stimulation environment for autistic litigants. Why this becomes a due process and Title II ADA problem, not just an empathy gap. 1. Credibility findings are among the most insulated judicial determinations on appeal. Appellate courts defer heavily to trial judges on demeanor because they're presumed to have special insight from watching the witness live. If that insight is actually systemic misreading of disability-linked traits, the deference doctrine itself becomes a laundering mechanism for discrimination in violation of Title II of the ADA. Nearly unreviewable errors get baked in as so-called fact findings. 2. This is a well-established evidentiary problem outside autism too. Eyewitness and lie detection. Research has shown for decades that lay people's and judges' instincts about who looks like they're lying have weak to no correlation to actual truthfulness. The cues people rely on, eye contact, pauses, fidgeting, don't reliably track deception, even in neurotypical population. Layer an autistic communication style on top, and the false positive rate for looks dishonest goes up further for reasons that have nothing to do with truth-telling. 3. Under Title II of the ADA, this converts into a services programs discrimination claim. A courtroom is a program of the state. Judicial fact-finding is a service being administered. If the methodology for administering it, i.e. demeanor-based credibility assessment, specifically systematically disadvantages people because of a disability-linked trait, that's disparate impact discrimination, even without any hostile intent from the judge. Intent is not required for a disparate impact theory of discrimination. The mechanism itself is the problem. Courts assume there's one language of honesty, and everyone who doesn't speak it fluently is lying. The double empathy problem shows that language is just one dialect, the neurotypical majority one, and treating fluency in it as a stand-in for truthfulness discriminates against anyone whose neurology speaks a different dialect natively. And so I want to break again for a minute, because what had happened next? Well, when we filed for a writ of certiorari and a writ of prohibition, alternatively mandamus, from the county court to the circuit court, then the writ was assigned to, once again, our local circuit judge, the Honorable George M. Wright. Now, the Honorable Circuit Judge George M. Wright is notorious as the one who has refused to give us any court hearing whatsoever in now more than 17 weeks and going on 18 weeks or more since we were walked off the property we were authorized to be on by the mortgage loan disbursement we signed for without any court hearing whatsoever. And again, this is the background of Circuit Judge George M. Wright. And so he's presided over notable cases. He has professional credentials. But what you don't see here, once again, is there's no mention that he has any specific autism educational training. Now, what else do we know besides the double empathy problem about the undercurrents underlying every court case and decision that involves an autistic person or an autism family? Well, there's a massive natural or unnatural aversion of neurotypical lawyers and judges and other neurotypical people toward autistic people and autism families. And how do we know that? Well, because there was a study, a scientific study published in 2017 in Nature. This study found that across 3 independent studies, autistic individuals' real-world social behavior was found to be robustly less favorable than neurotypical controls. The negative first impressions were consistent for both autistic children and adults, and they did not change with repeated exposure. Not only that, but neurotypical people then developed reduced intentions to socially engage with the autistic persons. And so we have this underlying innate and inherent bias in the neurotypical lawyers and judges that is inherent and innate in them the moment they come in contact with an autistic person or an autism family. It is negative. It is hostile. Obviously, it means that without specific mandatory implicit lawyer and judicial implicit bias training being required of them by the Florida Supreme Court, that they cannot give any autistic person or autism family any fair or impartial trial, and they don't want to have future interaction with the autistic person or autism family, which is why you see the autistic litigant and family member, the autism family losing every single case in the Florida court system, the judges disregarding the rule of law to make the autistic person and autism family lose, labeling the autistic person and autism family member as vexatious just to dump them out of the court system so they don't have to interact in the future, and all sorts of other discriminatory actions. So some of you level 1 autistic adults and you parents of level 3 autistic children, you may think that this has nothing to do with you and that you may never become involved in a court. Well, my mother passed away and my father tried to kill me and is estranged. So I got dumped out on the street as a level 2 autistic person. And if you think that you're going to live forever and you're not going to pass away and leave your level 3 autistic child out on the streets, well, maybe you set up a special needs trust, but guess what happens to it when you're no longer here and it goes into the Florida state court system? Well, we already know what happens, as the debacle and the looting and theft of Gavoni and the trust issues that surfaced in bankruptcy in Tampa in the Middle District of Florida have demonstrated. But I can assure you that autistic individuals and autism families of level 3 autistic people sooner or later are going to wind up in these kind of courts and experience these kinds of problems. On Title II of the ADA and the judge's conduct, these two judges' conduct, Honorable D. Tatum Davis, whose discriminatory credibility determination was upheld by the Honorable George M. Wright, and the Honorable George M. Wright, who is obviously manipulating hearings because, well, he hasn't given us any court hearing whatsoever for being walked off the farm we were purchasing, which was my autism environment. It took him about 1 hour to give us a hearing on the writ to uphold D. Tatum Davis to throw us out of the barbershop on the basis, ultimately, that the individual who owned the corporation could get away with cutting off the power and destroying an autism family business that supports an autistic person. So, on Title II of the ADA and the judge's conduct, Title II of the ADA prohibits state and local government entities, including courts, from discriminating against people with disabilities in services, programs, or activities, and requires reasonable modification to policies and practices unless doing so would fundamentally alter the proceeding. Now, several things were done wrong in this instance. There was disparate impact discrimination in the credibility demeanor assessment. Disparate impact. Rulings are standing orders that facially apply to everyone but predictably disadvantage autistic litigants, e.g. strict formalism, penalizing atypical communication, can violate Title II of the ADA. Disparate treatment based on disability-linked traits. If a judge is misinterpreting autistic communication style, flat affect, literal answers, atypical eye contact, direct language as evasiveness, bad faith, or non-credibility, and that mischaracterization is driving adverse rulings, that's treating disability-related behavior as if it were misconduct, a recognized form of discrimination. Denial of reasonable accommodation. If the autistic person needs extra processing time, written questions, clarification of ambiguous language, and this is denied or ignored, that's a separate Title II ADA violation. Autistic people all over the world are suffering and dying prematurely at disproportionate rates due to severe health issues and suicide. Research has repeatedly shown this across decades of studies. And we can add to that the discrimination of Florida state court judges who may not even be able to recognize their implicit autism bias and natural or unnatural aversion toward autistic people and autism families, but also are not being required by the Florida Supreme Court to undertake mandatory specific autism educational training. If y'all think this just happens to me as an autistic adult or our autism family, think again. It will happen to you. And especially as a level 1 autistic adult, if you have any kind of dispute over your job or a contract of any kind, it can happen to you. You have to go into a court or you get dragged into a court. Or parents of autistic kids, after you pass away, what do you think's going to happen to your level 3 autistic child if you don't already have a guardian before you pass away and he or she is simply living at home? What do you think's going to happen? This video explains to you what's going to happen. It happened to me. It will happen to you. And we need to do better. Thank you for watching. Please hit the subscribe button, like this video, and if any of you have experienced any of this, please tell me in the comments.